decided by the Ninth Circuit Court of Appeals. It's a case that involved a number of housing units that were disqualified from counting on the Housing Authority's inventory. Let me start over. The way that the Housing Authority gets money, the grant, the amount of the grant is based off of how many units they own and how many people live on the res. And for 1998, when NAHASDA started, these units that were counted were constructed back in the 70s and the 80s and on through the years. And so the people that purchased those under the terms of the lease, or not the lease agreement, the home ownership agreement, they had to pay off the house before it was going to be conveyed to them. But the feds got audited by the OIG, I think somewhere in around 2001-ish, and the OIG said that any units over 25 years shouldn't be counted, and that HUD should seek repayment for all those units that it had been paying, because the HUD gives the Housing Authority a certain amount of money to maintain those units, and they're saying get that money back for all the units that were over 25 years old from 1998 through 2001. And so HUD simultaneously sent out notice to every tribe that was getting the Indian Housing Block Grant, and every tribe said the same thing that Crow did, which is these units are not paid off. How are we going to continue to maintain them when they're not paid off? We can't transfer them. So they started this whole dispute of saying this is why we should have been able to continue receiving funds for them, and at the very least we shouldn't have to pay back everything that happened before this, because this is like it's new information. Well, one of the things that worked against the Housing Authority, or the Crow tribe in our case, is that when they sent that notice, initially it went ignored for about 2 years, and then finally when Urban, my uncle, actually started the case, the letters that they sent him were kind of confusingly written, and the regulations that they referenced for appeal weren't the right regulations, so he was not sure how to proceed, and what he ended up responding was, we dispute your determination. I'm not sure if this is the correct route, but if it isn't, please forward this to whatever route that is. The U.S. Department of Housing and Urban Development basically said, too bad you missed your opportunity to appeal, because you had 30 days to appeal and you didn't respond for even 2 years. So this is our final decision. Then Urban filed suit in district court against the Department of Housing and Urban Development, saying that we were at least entitled to an administrative hearing to determine how much money exactly was owed, because the way that HUD was figuring it was just kind of a blanket figure premised off of the inventory that they thought we had, and a number of those units would have still qualified under new, because they had new lessors. That's one exception to the requirement if it's over 25 years old. Even if you have a lessor that just started 5 years ago, then that basically means that they can, at least you can count it for another 20 years. So it went all the way up to the ninth. We prevailed in the district court in Billings. The court ruled that we did have the right to an administrative hearing, and then HUD appealed it to the Ninth Circuit Court of Appeals, and the Ninth Circuit Court of Appeals overturned the district court and said that HUD hadn't violated the statute because it offered us the opportunity to appeal, and we didn't do so within 30 days. So that's why we lost. So now that case is over. They reversed the district court and entered judgment in favor of HUD. HUD recently sent a letter to the Housing Authority requesting repayment of those units that were contested, and it amounted to approximately $1.2 million in alleged overpayments, and that counts from 1998 to 2008, I believe. We have, since that time, I think last month, we sent back a counter proposal that asking for a reduction in whatever amounts we can prove were expended on affordable housing activities, because under the law at the time, from 1998 to 2001, any money that had already been expended on eligible housing activities, HUD was not able to recapture. That was explicit in the statute. That changed after 2001, but at least from 98 to 2001, we shouldn't have to pay that back. And that'll reduce that amount by approximately $750,000, which is going to be amazing if it goes through. I don't know if it will, though, because we did have the opportunity to argue it out in court. That's one of the things that wasn't decided by the court, however, was whether or not we had expended those funds on eligible housing activities, so I think it's an open question. Any questions on any of that? I know it was a long story, sorry.
Dennis, maybe you can inform the district here, what do we owe HUD in back taxes or back pay, or what we owe other than this, and how can the tribe bring in more funding for homes in Mighty Few? What's the process?
Okay, so as to the first question, as to what the housing authority owes in back taxes, back rent. Does anybody know how much is overdue? I don't have those figures. You don't know what the overall is, though? Okay. So it's apparently a lot.